consultations. And grant that, we having thy fears always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsel may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This Honourable Senate now resumes its sittings, and just as I did last week, I wish to welcome members of the public who have attended to observe the continued debate in relation to the legislation presently before us. Minister?
Thank you, Mr. President. Mr. President, we had a long sitting on Friday, and it proceeded into the morning of Saturday. And we are here again once more at a special sitting to do the work of the people of Jamaica. And we too welcome the persons who have come to witness this and to understand the process better. As you have indicated, this is, on more than one occasion, this is the People's Parliament, it's Jamaica's Parliament, and we encourage and welcome everyone who comes to be a part of the process. Mr. President, it would be remiss of me to start the business before this Senate, which is to pick up where we left off at clause 20 of the bill, where we left off after 1 a.m. on Saturday, without addressing an unfortunate incident which took place on Friday earlier in the day. And I want to, for the record, I've already issued a statement on the matter, and so certainly that is in the public domain. But again, for Hansard, again, for Senator Floyd Morris's self, and for myself, as I shared with him this morning, I think we have both been hurt by the incident, although admittedly his concerns are certainly greater than mine. I wish to apologize wholeheartedly and sincerely for any and all distress or offense caused to Senator Morris by my comments. Senator Morris, through the President, you have my deep and sincere apologies. I meant absolutely no disrespect. I meant absolutely no offense. And I regret that the entire incident took place. I want to state it here for the record. I want to state it here for you. And I want to state it for the members of the public who are listening and who may be concerned about the incident which occurred. Thank you, Mr. President.
Thank you very much, Senator Morris.
Thank you, Mr. President. Mr. President, Senator Johnson Smith, know that you have recognized that you have been wrong in the statement or the comment, and you have apologized. I sincerely accept your apologies.
Thank you very much, and I would just like to thank both leaders, leader of government business, leader of opposition business, and Senator Morris for a very productive meeting that we had this morning. And one of the things that arise out of that meeting, I recognize some of the difficulties which Senator Morris has been facing, not recently either, over a period of time. And Madam Clerk, I am to once again request that Senator Morris, and indeed all senators, receive their documentation for meetings in the appropriate time, to the extent that you receive them, and also in relation to the particular format that Senator Morris requires his documents in. He assures me that he gets the full cooperation from the clerk and the assistant clerks, deputy clerks, but I'm just reiterating again that there is a need for Senator Morris to get the document. The technical part of it, I'm sure you are aware of, but it's a particular PDF format. So please ensure that that is done. Thank you, Madam Clerk. Statements by ministers. Announcements.
Laid on the table of the Senate today is the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selection Estuary Housing Development Order 2017.
Bills brought from the Honourable House of Representatives. Petitions. Papers. Reports from committees.
Mr. President, I beg to lay on the table of the Senate the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selections Estuary Housing Development Order 2017.
Thank you, Senator.
So just a clarification, Mr. President. Someone thought this was laid on Friday.
The clerk is saying that it should have been, but it wasn't. It was circulated, but not laid. Thank you, Senator Samuda. Notices of motions given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selections Estuary Housing Development Order 2017, which was laid on the table of the Senate on the 13th day of November 2017, be approved.
Thank you, Senator Samuda. Questions and answers to questions? Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. Presentation of bills without the leave of the Senate first obtained. Public business.
Mr. President, it is intended today to continue the debate on the National Identification and Registration Bill 2017. We had left off, as indicated, at clause 20, and it is proposed to start at that point in committee.
The Senate will now resolve itself into a committee of the whole Senate to consider clause 20 and the concluding clauses of the bill shortly entitled National Identification and Registration Act 2017.
Mr. President, with your leave, just to clarify and ensure, because we have had some administrative issues here, I just want to confirm that everyone has received the merged document that is a single document which has the tracked changes of the amendments which were tabled on last Friday and the amendments that were tabled on the previous Friday. That the single track change document has been received in email and in hard copy, because I just want to confirm that. It's on your desks. And I hope that this will help to facilitate today's proceedings.
Mr. President, I just want to register my personal appreciation that I have received that document yesterday, and in fact this is what I was asking for on Friday when I claimed privilege in this honorable chamber. and I want to express my appreciation for receiving those documents.
Thank you very much, Senator Morris. Minister, you were at clause 20. What? I said it already.
Thank you, Mr. President. Mr. Chairman, pardon me. Yes, we were at clause 20, and we were in fact engaged. Senator Knight, I'm not sure. I certainly know it was our first, and I suspect it may be our last early morning or late night conversation about, about clause 20, subparagraph 14, the clause that was dealing with the alternatives to the fine. And I wanted to start with us looking at the fact that we did further research over the weekend. Again, in recognition of the fact we really are trying to work to get the best bill possible, but of course with the greatest efficiency possible. Your proposal had been that we say that a parish court before which a person is convicted of an offense under subsection 11 may, instead of sentencing, that it be converted to shall. And my concern was that it was a separation of powers issue. And I've done the research, and we've had the technical people look at this, and they have assured me that that change is in fact possible. So I would like to also start this morning off on that positive note of suggesting your proposal to convert may to shall, and we're now on page 6 of this merged document, where you would find the clause that had been looked forward. Well, clause 20 is before us. This was a clause that we were discussing on Friday, and that's why I've put it before.
Mr. President, I know that we have started working on this particular clause Friday, and we are now at subsection, what, 13? 14, okay. And, pardon me? Okay. Because I have some concerns in relation to this particular clause, in particular 7, 27, and 29, because all right, members are asking, Mr. Chairman, that we start from clause 1. 21, but I just want to express my concern here because these clauses speak specifically to the mandatory nature of the registration, and I have some concerns as it relates to persons with disabilities based on experience that we have had to register persons with disabilities at the Jamaica Council for Persons with Disabilities. And Mr. President, in order to register persons with disabilities, a medical practitioner, a specialist, have to verify that the person has the particular disability because, you know, there are certain benefits that persons with disabilities would be entitled to under different legislation now. For example, the Income Tax Act. And so they have to be declared as individuals with a disability. And they have to pay for the service. They have to pay for the service. Now, I want to find out, in light of the mandatory nature of this legislation, this particular clause, if the government is going to be taking charge of paying those fees for the medical specialist in light of the mandatory nature and the challenges that persons with disabilities face. And there are certain disabilities, Mr. President, that you have to give specific attention to because, for example, individuals with intellectual disabilities, the government don't have the appropriate assessment mechanisms to assess individuals with intellectual disabilities. And these services are by and large done by private individuals. And so I want to know again if the government will be taking care of those expenses, because further down you see that there is an offense if the individuals are not registered. And I would not like to see persons with disabilities being charged as a result of their inability to pay for the services that would allow them to be declared with a disability and to give accurate information to the authorities. So I would want to get some clarity from the Honourable Minister on that.
Thank you very much for that inquiry. The Senator, as you know, we met with the Jamaica Society for the Blind, the Jamaica Association for the Deaf, the Council for Persons Living with Disabilities, and the Jamaica Association on Intellectual Disabilities to discuss these same issues about how it is that we make sure that the process is truly inclusive. And we are working, and what was agreed, as a matter of fact, at that meeting was that we would have an MOU that set out a framework to work with them to ensure that we have, throughout the process of enrollment, operationalizing, and even drafting of the regulations, to make sure that their views and concerns are taken on board. Now, we have said that, so your NIDS is free, your ID, the ID number is free, your first ID card, and every renewal is free. It's only lost cards that you will have to pay for, right. The renewal. But your card is free and your renewals are free. Similarly, persons who don't have their birth certificate in order to get the NID will be provided free of cost with their birth certificate. The registrar will facilitate that. And we are working with the Council of Persons with Disabilities to implement an appropriate process to make sure that there is no burden on persons with disabilities who have to register. But I also want to point out that the clause that creates the offense, that is 29 in the bill but renumbered 11 as a result of the amendments, it makes it an offense for every person who refuses or fails without reasonable excuse to apply for enrollment commits. So the issue is that as we had said, and most of the feedback from the groups that we had met with had been that this system would not work unless it was mandatory. Everybody needs to, should come on board so that we have a system that is ubiquitous and works fully, and that is not a piecemeal attempt at implementation. So that the issue here is that the framework is not intended to criminalize and penalize. The issue is to try and incentivize and to facilitate everyone to get on board, but to also have an indication of the seriousness of the commitment to ensure that this is in fact rolled out in a way that is useful, that is inclusive, and that where persons might not normally be moved to do something because they just can't bother, they might take it seriously as we continue, of course, to educate and demonstrate to Jamaica the utility of the service. So the answer is that we're working with the Council Jamaica Council of Persons with Disabilities to ensure that the process that we develop and the for registration and otherwise, that it will be fully sensitive to and not impose a burden on persons with disabilities.
Minister, I hear what you have said, and you know, I just want to point out that I am not totally satisfied with the response, because I know that in order for persons to be declared with a disability, they have to go and get specialist attention. You have to go to either the ophthalmologist if you are blind, you have to go to the audiologist or one of the specialists that deals with the particular disability, and it's very expensive. Now, I don't know of the Jamaica Council for Persons with Disabilities having the capacity to respond, to give support to those individuals, because last year, in terms of budgetary allocation, the JCPD received $95 million to cater to the needs of persons with disabilities and administrative expenses. Now, if you are to look at the total population of persons with disabilities, and if I am going to ignore the estimates that are out there and go by the latest data that is available, which is about 2001 census, talking about almost 168,000 individuals. And if I'm to go by that, recognizing that the vast majority of persons with disabilities are poor individuals, and you should do some mathematical calculations, you would see that it would require significant resources for the JCPD to assist those individuals to get the medical attention so that they can meet the requirements. So that is a resource issue that will have to be addressed in the whole process. JCPD will have to get additional resources in order to assist those individuals to register so that they don't run afoul of the law.
Understood, Senator, and it will be. And I was explaining to you, giving the example of the birth certificate, of the type of support that will be given. So this is in fact, and I've just gotten the confirmation from the project manager, this is in fact one of the very real and tangible ways in which NIDS will assist persons with disabilities, because the NIDS project is providing for the medical support to get these certifications and diagnoses so that they can be properly identified as persons with this disability, so that we can plan and provide support for them. So it will not be a cost. How we operationalize it will be worked out with the Council of Persons Living for Disabilities, because they best are able to communicate to us what will work well for people living with disabilities. So as I indicated, we are committed to working to ensure that the system is fully inclusive, and we will be bearing the costs of whatever process that we agree is appropriate for their inclusion in the system, and to support the planning to give better support to persons living with disabilities, because this is again one of the areas in which our society has massively failed. So this is, and thank you for highlighting, one of the benefits anticipated of the NID system. So the support will be given, Senator, and lawful excuse would certainly ensure that any person who is unable to, who will not have registered at the time that this clause becomes implemented, becomes effective, because remember as well that this clause is one of the clauses that are not going to be enforced at the outset, the penalty clause. It is one of the areas that when we have a majority of Jamaicans on board, that is when it will come into effect. So the process will have an opportunity to be well structured and phased as we anticipate before the issue of penalties arise.
Mr. Chair, I want to go back to clause 1.
Senator
Flight
Scarford.
Flight finish? Okay. I want to...
Senator Scarford.
No, that is... I want to go to clause 121, because we're talking about what the system will do or will not do. But I think as we speak about a phasing, then it's best not to make it mandatory in the initial stage. And I am proposing that to replace in clause 21, shall with me. There's a review process after 18 months. And we use public education, persuasion, and other means to get a buy-in from the public in a non-mandatory way. And during the review process, we can assess where we are. In that case, there will be no need in this initial stage in the bill to have punitive measures so as to force persons to respond as we seek to get that total collaboration and cooperation from our citizens. And since we are saying the punitive measures will not take effect now, then why are we not put it in the bill from now when we have a review in 18 months? So I think it should be non-mandatory in the initial stage as we assess the progress and give our citizens that opportunity to freely understand the objectives and the implication and have that participation going forward. So I'm proposing, and that would solve some of the issues that Senator Morris spoke about a while ago, because it to be non-mandatory. So replace the shall with may, and we'll solve the issue as we pilot this bill, quote unquote, and move forward to get the country understanding the benefits that they may be, and more importantly, the implication. Cannot be punishing our people to enroll in a system that we have yet fully educated our people on.
Chairman, before the response, I'd like to.
Well, let me just try and let the minister respond to that first. Let the minister respond. You mightn't have to. Go ahead and.
Yes.
But oh, go ahead. I just wanted to indicate that in the process of discussion and in the process of consultations, a lot of the feedback that came from persons, including the opposition, was that the system would not work if it was not mandatory, that the system was unlikely for everybody to get on board if it was not mandatory. So what we have put here is a clause to make it mandatory, but I've structured the bill in a way that all the clauses do not come into effect at the same time, so that we can properly phase not only the rollout and education, but also when it is that there will be any effective penalty. So the penalty clause will not come into effect for a number of years until persons are enrolled. But we do want to make a clear statement of the policy that makes it clear that this is going to be the new way of doing business here, so that we want to include everyone, and that it is only further down the line, having run the parallel process of education, to that we will bring online the clauses that were raised by, the clause that was raised by Senator Morris.
Yes, Chair. Again, as I said, I want to add my voice, because if it is that this effort has so many benefits to the people, why is it that we're assuming they would not know what is good for them? If it is that there's so much good to come from it, then they would volunteer with information to participate. Now, to coerce them at the first instance, when we have said that we have no intention to implement in the next few years, there are methods and methodologies in place to come back to review a policy. So if it is that you have no intention to implement, then your marketing and communication could indicate that this is the way of business in the future. But I don't believe it needs to be on the books at this particular point in time if there is no intent to make it mandatory. At the point that that intention becomes clear, then the government can come back to the House to actually say we want this to be implemented and discussed. But if it is that there's no intent, I don't believe it is necessary to be placed currently.
Mr. Chairman, it seems to me that the process that the ministers articulated, where it is not being implemented immediately insofar as the penalty, in addition to that, the policy framework that is being articulated, which is that it is intended to be compulsory at some point. In my own view, if you make the education process be adequate over a long period of time, you make the opportunities to make use and to gain the number and the card over a long period of time, then in due course, when that time comes, as articulated, it will be appropriate to do it that way instead of coming back and confuse and have a debate about the issue 2 or 3 years down the road. I think the safeguards articulated by the minister is adequate.
Mr. Chairman.
Chairman.
Senator
on
Knight,
this point.
Just Senator Knight, go on then, Fraser Binns.
On this point, clause 1 speaks to no, clause 1 of the bill speaks to the coming into being of the bill on appointed days. Now, it would seem to me that at this stage, the government would know exactly what the timetable is for the full implementation rollout of this bill. And so, for example, if it is that the minister could, before we're finished, indicate which sections would come in when, because there has to be some logic to the way in which the sections are brought into being, and that logic would be linked to the policy. Then that would, assist us to know, because as it is now, it is almost it's not an undertaking. It is an intent. And whilst I'm prepared to, accept an undertaking, an intent is not sufficient in these circumstances. And the undertaking can be underpinned by the appointed day. So it doesn't need more than indicating the appointed, the days that would be appointed and the sequence. I am not asking now for you to say, well, the appointed day will be the 21st of March, 2020, but just that these sections would come in first, followed by these sections and these sections. Then we could understand the sequencing. So that's my point on that aspect. I have some other thoughts on Section 20, but I will yield to Sophia, to Senator Binns.
Thank you, Mr. Chairman. Minister, you have stated expressly that Section 9 will not come into effect until a time in the future. But you have not given any indication as to at what point will Section 20, subsection 1 comes into effect. I ask you that because in my mind, if Section 20, subsection 1 will be coming into effect prior to subsection 9, then in my mind it makes very little sense, if any at all, for Section 1 to be mandatory. So I would first want to find out from you, 1, when do you envision subsection 1, which makes it mandatory to come into effect? And secondly, if it is not envisioned that it will come into effect immediately, then I am recommending that that section be deleted, and at the point of review 18 months from now, that it be considered.
Mr. Chairman, part of our consternation in this House and the public consternation is the mandatory aspect of the bill. The bill, in my view, has to be mandatory to give effect to the policy. But it's the how and the when that you make it mandatory. And I think that the public concern would clearly be addressed if it was not mandatory to begin with, but at the stage when you were satisfied at the level of enrollment, you then made it mandatory. And I agree with my colleagues that the review for every 18 months gives you that obvious opportunity. In the meantime, your public education program, your various contacts with the public would certainly inform some other aspects of the bill which you might also want to review within that time frame. I think that a lot of the consternation, as I said, a lot of the mischief which one sees with the legislation would be addressed if it were made initially voluntarily.
All right. Thank you, Senators. The concerns which have generally been expressed in the public have lain around the issue of a fine, the issue of the fear of imprisonment, the fear of the criminalization of the clause. This is what I am hearing in the feedback and in my observation of the things that are being circulated on social media and otherwise, that it is the contents of that clause 20 sub 9, renumbered 9, that contains the penalties that, and 14, of course, which in terms of it understanding its scope, where the issue lies. The policy is that everyone should be a part of the NID system to make it work. Everyone should have access, everyone should have the benefit, everyone should be a part of it. But recognize, and the policy is that everyone will be a part of it. The process, the phasing, the ordering, the structure, and the timing of it is where we can manage, as well as the point at which enforcement comes into place. And what we have said is that we want to be clear on the policy, that everyone will be included on this. Everybody shall be a part of NIDS. But we will not enforce with a penalty until after the majority of Jamaicans are on board, and we have had the benefit of the parallel education process. But the policy is quite clear, and Senator Knight had raised, in fact, several members on the opposition had raised concerns last Friday as to whether we were clear on the policy. We are clear that all Jamaicans, we want all Jamaicans to be a part of this. So we think that the appropriate balance has been found in leaving 21 as mandatory and in not bringing into force a penalty. So there will be no penalty for a number of years in respect of anyone's failure to enroll. And as I explained when in my interchange with Senator Morris, that there is the proviso in that clause 20 sub 9, that it is where you fail without reasonable excuse, Even so, even years down the road, you still have the opportunity to explain why you have not, and it can then be facilitated without it having been. And I want to also make it clear that 2014 is also, not 2014, we'll find the clause, but it is enshrined in the amendments that it will not be part of a criminal record either. But again, that is down the road when that clause comes into effect. Now, as to Senator Knight's question about the rollout, I want to give some indicative, a greater sense of what is planned. And as you would recognize, as with any project, you set a project timeline, but you cannot be specific. And this is why, in the sense that we cannot legislate the time. And in respect of legislative process, you would also recognize that it would be extremely unusual and ill-advised to put the contents of what would be in your appointed day notice, which is what the instrument that will clarify when clauses will come into effect, for you to put that in the bill. That is not generally done, and Senator Knight, a man of your experience, would of course be aware of this. So no, he remember we had an interchange last week. It can't be that he was saying to me that he's more experienced, and in fact quite slapping me down on it. I know he doesn't take offense to that. It is something he celebrates greatly. But I want to just share. You don't want me to go with this. You want to interject before I proceed with the rollout.
Let me tell you my real difficulty with it. Ministers come and ministers go. Governments come and governments go. And there is always some uncertainty when a new minister takes over, and the more so when a new government does. And what we're looking for in this bill is something, remember, this is new. It's new. But there has to be a logic to the rollout. And it is that logic to the rollout which would inform the appointed day notices. That logic doesn't necessarily have to come after the entire bill has been signed by the Governor General. The logic precedes that. The logic is developed now. The government of the day must take responsibility. And the government of the day must say, this is the policy, this is how we see the rollout, and this is what we are telling the public it will be. Because it is not for the edification of the parliamentarians. It is for the comfort of the public. They need to know. So that whilst it has not been done before, it does not mean that there isn't a door now that we can open. And so we can do, this is new. And the approach to appointed day can also be new. And my recollection is that when the legal aid bill was passed, it had two aspects to it, the criminal and civil. And it was indicated in two separate sections of the bill. It was indicated that clauses 1 to so and so, the criminal aspect, was going to come in first so that the public knew, and the Ministry of Finance would have been greatly interested because of budgetary allocations and so on. So there was some certitude. All I seek here is certitude and understanding also that circumstances can change. And if the circumstances change, then what would happen is there would be an amendment to the bill, which is ordinary. There's nothing to be ashamed about amending a bill. That's how legislation is developed and etc. So I am still in a position of discomfiture with your reluctance.
Thank you, Senator Knight.
Senator, if I may be permitted to relieve some of your discomfiture, but it seems to wish to say something.
Go ahead and relieve some of his discomfiture if you can. Relief of discomfiture is always a good thing.
If I may at least try. I will at least try. So, my position holds true in terms of treatment of the appointment day. I think that that is most appropriate for this, something with this complexity as well. But I want to, as you rightly say, share a greater understanding of how it is intended to roll out so that we can better understand how it will work. So the implementation plan, essentially, it is intended to put the infrastructure and systems in place over the next 12 months, which is why it is so important not to lose the year. The pilot would begin in January 2019. So pilot group would be brought online in January 2019. And the national rollout is intended to commence in September 2019 over a period of 3 to 4 years. Remember, NIDS is not an event, it is a journey, it is a transformation of how we do business.
That's for the conversation. No, I want a clarification. I'm seeking a clarification.
So make her finish and then you seek the clarification.
No, but I want a clarification on the point that she's making. So is this a debate?
Look here, it's not a debate.
Or a lecture?
Come
again?
It's
a lecture or a debate?
Come.
Is it a debate or a lecture? No, but we have used to us in the debate stopping for a point of clarification.
No problem.
What's wrong with that?
She's finishing a point.
Having a point of clarification, that's the norm. We are in committee. We are in committee, not disrespectful. We are in committee. I'm asking for a clarification.
But I have given the minister the floor, allow her to finish.
Okay. Now, you finish, I'll come after. No, man, you go ahead.
Please proceed.
No problem. Minister, thank you very much. You have something you want to say, Mr. Skeffrey?
Yeah, I'm asking the minister his keeper and tell us about the policy. We are here debate them seeking to pass a bill. And she's talking about 20. Where in the bill or where will we have those timelines?
Okay, no problem.
So don't finish that, Mr. President.
I thought that she was responding to a question asked by Senator Knight.
Yeah.
And let me just say something. Strictly speaking, the minister is totally wrong. Because we are in committee,
so you are
and we're supposed to be dealing with the issues, the details of the bill. So, Minister, you are not permitted to be giving any statement in relation to policy, nor is anyone else. So
I'm
here
seeking
we are
clarification, Mr. President. I can't give permission about a bill. I'm not passing the bill.
Good. Well, listen. Well, what we do? I agree. No, hang on a minute first. I agree with Senator Skeffrey. 53 of the standing order says, any committee to which a bill is committed shall not discuss the general merits and principle of the bill, but only its details. So that is what we are going to stick with. Thank you for pointing that out for me, Senator Skeffrey. Senator Brown, you have a point of order?
President, Chairman, there seems to be a misinterpretation of that and a misunderstanding of what the leader was doing. We weren't discussing the merits. What we were discussing is how can the policy be implemented. We're not dealing with the merits of the policy. That's accepted. And it is because that is accepted why we can go on to implementation. Because you can't discuss implementation of something you don't accept. So the minister, with the greatest of respect, was acting appropriately in doing so. And if she had not, that is where now there would have been great discontentment.
That you're talking to Senator Skeffrey?
Talking to the persons who are sitting within this chamber.
Very good. So we are at clause number 2. Oh, Senator Brown, I think you wanted to say something.
My concern, President, is that when we start a process, we can't then just change in midstream. Because I watched carefully the fact that you gave the minister, Senator Bryan, latitude. And I expect, therefore, that latitude is going to be given to us. Yes. And I say this because I read in the newspaper over the weekend that you made certain comments. I'm not going to attribute it to you because it wasn't quoted. But I was waiting for you today.
No, man,
if
but you must, if you have a problem with something that I said, let me hear and let me say it's true or it's not true.
I am speaking, President, because I want to make it clear. I have said, Chairman, I've seen it. I'm not attributing it to you because it was in quotation form, but I'll have hoped that you'll have come here today, also having seen it, to say that's a misstatement.
So how you know I've seen it?
That's a misstatement.
If you don't tell me what it is, how you know I see it?
It is a quotation, is a statement in the Observer which says...
Chairman, on a point of order. Chairman, on a point of order, I cannot see where the member is going with his presentation in regards to this particular clause.
Mr. Chairman, if I may.
So let me finish.
You can't interrupt Senator Brown, him don't finish.
To delay the bill. And what that says to us is that if the president holds those views, then the president would not be partial, but would have taken would be partial rather than taking an impartial position, right? And that is of concern to me and my colleagues on this side. And it would be good, Mr. Chairman,
on a point of order,
Mr. Chairman,
if at some point that is being made, he's imputing motive.
Those views which the observer said belongs to you are in fact not yours.
A point of order has been called,
means
Senator
a lot
Brown.
to us on this side that the chairman
Senator Brown.
must operate in an impartial manner.
A point of order has been called, Senator Brown.
Right?
A point of order has been called.
Chairman, I respond to the chairman.
Senator,
I respond to the chairman.
1 minute, please. Senator Brown, tell me when you are finished.
That's what I would intend to do, Mr. Chair.
Okay.
So I'd be happy, and we'll be happy, if it is made clear that what we are doing on this side, that the minister said this morning was a process of making better law, would not be seen as an attempt to delay and to impute motive to the opposition that does not exist. And if those are your views, Mr. President, I'm surely disappointed. At this point, I don't believe it's your view, and I believe it is the irresponsibility of the Observer and their journalists.
Section 21, that's where we are. Clause 20, that's where we are. Any other comments on
yes,
clause 20?
Mr. Chairman. Mr. Chairman, we're still at 20 subsection 1. And the minister mentioned earlier a timeline. And we have the second recommendation that we now have is for that timeline to be placed in the bill. And it is not unusual. Senator K.D. Knight mentioned it was done in the Legal Aid Act. But I do recall that there was some timeline provided in the recently concluded pension bill that we debated just last month. So it is not unusual. And if you just bear with me, please, Mr. Chairman, I think this is so important because the crux of Section 20 lies in the fact that we are asking for this provision for the NIDS to be mandatory. And we're also saying, Minister, that if based on what you have said, that though it is mandatory, there will not be a fine, then we believe that to give comfort to Jamaicans, the best we can do at this point, seeing that there seems to be a policy of not accepting our recommendation, the best that can be done to give comfort is that we state these things in the bill. Once they're in the bill, there's absolutely no doubt in anybody's mind that takes up the bill to say this is what is there. So I'm asking Minister, one, first, that we change the shall to may.
Okay, Senator Binns.
That's the first recommendation, sir.
Just be clear for me. You are proposing that the word shall be changed to may. That's number one. And the second one?
And the second proposal, and I hope, sir, that you will put them one by one.
Yes, I know, of course.
The second proposal, I'm being guided, sir, that I'm being guided that we shall like you to put the first, proposal for us to.
No.
The alternative then, sir, is that the minister inserts in this bill the timeline and the sections that will be coming into effect, as well as the implementation timeline that she spoke about shortly. Those are my two recommendations,
I'm going to ask
sir.
the minister to respond to those two specific things, and after which, if necessary, I'll put it to a vote and we move on.
Thank you very much.
I still have, you know, I don't know if you want me to do it now. I'm moving on to...
Let me just deal with this first, because this is actually 21, so let me deal with one first.
It's clause 20 that I'm dealing with.
No, I'm saying the proposal by Senator
No,
Bill.
but that's not how you put it. You can't put it like that.
Mr. President, what he's suggesting is to put forward all of the proposed amendments to the subclauses in 20 so that we can agree the amendments to the amendments and the amendments to the clause 20 in one go. So I'm happy to...
That is perfectly clear to me.
Yes, thank you.
Senator Knight, go ahead now.
In relation to what is now clause, well, firstly, 26, it still exists, right? This is just a typo. The authority, I think authority there should be in capital. And in relation to what is now 10, which I think will be 12, it's contravention in the second line. But the point that I was making on the last occasion was that this offense ought not to be on one's criminal record. And the response was that section 2012 indicates that. But 2012 is specific. It says for the purposes of the Criminal Records Rehabilitation of Offenders Act. It's limited to that. As I understand it, the Criminal Records Rehabilitation of Offenders Act is dealing with a situation where the relevant authority is dealing with spent of convictions and expungements and so on. And if one commits an offense within a specified time, then it affects the whole process for the Rehabilitation Act. So they're saying, don't count this as an offense for those purposes, and for those purposes only. So it would be on the record, the criminal record. And I'm saying that an offense of this nature ought not to be on one's criminal record. And it's clear that that is the policy. And what is happening is that the implementation of that policy is not reflected in the legislation. Otherwise, what is going to happen is that you're going to have people who, when they apply for a job, they're going to be asked, do you have a criminal record?
Senator Knight, you could give me a proposal.
Pardon?
Word of proposal.
Well, I don't take on the position of the drafts people. I must tell you the truth, because they are specialists, and I am not. But just that they capture that.
Senator Knight, thank you. In respect of this issue, the this is the exact formulation that was used and is found in 7G10, 7 big G10 of the Dangerous Drugs Act, Amendment Act, that was passed by under your administration. And my understanding of that clause is that the intent is that it will not attach to the criminal record because so that expungement doesn't arise. It doesn't actually go on the record in the first place.
Oh, it attaches to the criminal record. But when the consideration is being made about under the criminal Records Rehabilitation of Offenders Act, that conviction cannot be taken into account, but it is on the person's record. But for this act, for the purposes of this act, it is not to be considered and is not considered, but it is on the record.
My understanding is that this actually will not create the record because the same act is responsible for the framework that sets out the creation of the record.
No.
Yes, it deals with expungement, but it also speaks to the attachment of the criminal record. But no, Senator, so you have raised a technical issue. So I'm going to take technical advice because, as you have stated, the policy, and you have confirmed that you understand that our policy is that it shall not form part of the criminal record.
Right.
So it is important that we get the clause right. My advice is that it is perfectly correct. You strongly feel that it is not. So I'm going to ask the technical team to just look at the issue more closely for me while we look at the other clauses.
Go ahead. The technical team so advised, and I'm persuaded I will back away.
Much appreciated. Yeah.
In the same act, Senator Knight.
So just to be clear, by the way, just to be clear that it is. Oh.
I was saying, Senator Knight, the Criminal Records Rehabilitation of Offenders Act actually creates the record, not only expunges the record. And so what it is intended for this clause to do is to say that there will be no creation of a record that could be expunged. And so, no, but this is, I understand, but this is the same formulation that is used elsewhere in that regard. Okay? Because this act not only deals with expungement, but the creation of a record. This is saying no record can be created to ever be expunged.
Chair, I want to speak to clause 9. Every person who refuses or fails without reasonable excuse to apply to the authority for enrollment in the database in accordance with the section commits an offense. Where I'm concerned is what is without reasonable excuse. Would that include religion? If it includes religion, is that religion as accepted by the law or as is practiced or as is popular or as is perceived? What is it that is perceived to be with reasonable? Yes, 9 has been renamed 11. So, for example, if Rastafarianism isn't acknowledged as a legitimate religion, if religion is included, is Rastafarianism excluded because it isn't acknowledged? If some variation of Christianity isn't acknowledged, though you accept Christianity, what is reasonable and who perceives this to be reasonable excuse?
I will ask.
Mr. Chairman.
Just hang on a minute, please. I will ask that what he's seeking a clarification as to what is reasonable.
Mr. Chairman, insofar as that question, without a reasonable excuse, that is a very wide phrase. And indeed, when the authority, if you wouldn't want to restrict it, because right away the senator, where I know, indicate the breadth of the phrase. It is that very breadth that makes it very valuable to the citizen. I would leave it like that, and it can encompass any reasonable excuse. The phrase speaks for itself.
Well, Chair, it is the same.
Look here, let me tell you what you're going to do. If you have a difficulty with it, then make a proposal and we put it to the vote.
Well, Chair, I'm trying to understand if I have a difficulty. I'm trying to comprehend what is being suggested and what is being intended. There have been quite a few statements of intention that wasn't reflected in the bill. So therefore, I'm trying to understand the intent, to therefore understand. Because what is said here, Chairman, is that, and my understanding is, it is a court that would seek to determine what is reasonable. And with the court who's determining what is reasonable, would the law then be the basis of determination of reason? Would it be to say that Rastafarianism isn't acknowledged by law, a religion, and by extension is unreasonable, while Christianity is acknowledged and by extension is reasonable? So therefore, I think that the breadth should demand some explanation as to the parameters of that width. Is it very wide or is it not very wide? The bill should indicate that.
Mr. Chairman, as with all other laws, my understanding is that the definition of reasonable would be that which is related to the ordinary and prudent person in our country. And so I don't think that it is something which would be difficult to appreciate. It is used in several pieces of legislation and for decades has been applied in that format successfully.
Thank you very much, Senator Chair.
Chairman, do I have your permission? I'm asking if I have your permission to speak. Thank you very much, sir. Chairman, depending on the position arrived at, I'm minded to make an amendment, a further amendment to right here 20 in respect to what Senator Skeffrey proposed to delete shall and replace it with may. But I also want to, in making that proposal, indicate that what we're doing here is passing law in the Parliament. It is the Cabinet that sets policy, but it is our job, not that of the Cabinet, to pass laws. It is for the court in the separation of power to interpret not the policy, but the law. First, the law. And if the law does not say what the policy is saying, the judges are going to interpret the law. And as the law stands now, somebody who goes before the court because some constable says you're not registered could face things. And which is why we are insisting that in the law, a period shall be stated where this will not be applicable.
Senator
and
Brown,
as such, Mr. President, my proposal would be, my amendment would be.
That's the same amendment that
No, it's not this. No, I'm making another one. I wish to state and to propose that at 21, after 23, we insert a new 4 and renumber the rest going down. And that 4 be that registration and that enrollment under 21 will only take place after a referendum is held in which 85% of the people approve of this. And this is consistent, Mr. President.
Senator Brown.
Chairman, this is consistent with the call for referendum by my friends on that side. It's consistent with their view about it won't be implemented until the majority takes place. So that my amendment calls for a referendum which will determine the views of the majority, and it's consistent with their policy.
Senator Brown,
referendum on Bogri, referendum on Ganja, referendum on CCJ, and referendum on referendum.
No problem. So here we are. Listen, the first proposal is that section 21 be amended, replacing the word shall by the word may. And I put the amendment. Those in favor? Aye. Against? The noes have it. I heard, Mr. Brown, I heard. The noes have it. There is a divide. Senator Reid, I don't wish any crosstalk, and it applies to everybody, including you and Senator Nye.
All right, I'll be quick. Senator Braham, Senator Brown, yes. Senator Charles, Senator Crawford, yes. Senator Fraser Binns, Senator Gale, no. Senator Hill, he's absent. Senator Johnson Smith, Senator Knight, Senator Knight, Senator Longmore, Senator Morris, yes. Senator Morrison, no. Senator Reid, no. Senator Samudo, no. Senator Scott Motley, yes. Senator Sinclair, no. Senator Skeffrey, Senator Slowly, yes. Senator Webby, no. Senator Williams,
I do report the result of the divide. 8 ayes, 10 noes. The noes have it. The second amendment I put is to add a section, or to replace section 4 with the following. Enrollment under section 21 will only take place after a referendum is held in which 85% of the people agree.
That is not a replacement of 4. It's bringing in a new 4, and 4 become 5. And
yeah, so that is replacing this 4, and then the other 4 will go down.
Yeah.
Okay, good. So all in favor of that? Aye. Against? No. The noes have it. There's a divide.
Senator Braham, Senator Brown. No, you have to be here. Senator Charles. Senator Charles. Senator Knight. Senator Crawford. Senator Fraser Binns. Senator Gale. Senator Hill. Senator Johnson Smith. No. Senator Longmore. Senator Morris. Aye. Senator Morrison. No. Senator Reid. Senator Samudo. No. Senator Scott Motley. Senator Sinclair. Senator Sinclair. Senator Skeffrey. Senator Slowly. Senator Slowly. Senator Webby. Senator Williams. Senator Hill.
I do report the result of the divide. Noes 8, ayes 11. I'm sorry. Ayes 8. Ayes. I do report the result of the divide. Ayes 8, noes 11. Thank you very much. I now put the amendments to section
Mr. Chairman,
21.
Mr. Chairman, if you may recall that I made a second proposal relative to the timeline.
Please? Can I have it, please?
That the timeline, that their section be inserted that provides a timeline within which the sections of the bill will be implemented or come into effect.
Thank you very much. The question is that a section be inserted into clause 20, which states the timelines to which the minister has alluded. Those in favor? Against? The noes have it.
Chair.
1 minute, please. There was a discussion in relation to something that Senator Knight had proposed. Can I have it, please?
We've discussed how it is that we make it absolutely clear that 2010 no 12
does not attract a criminal.
Does not attract a criminal penalty.
Criminal record.
Criminal record, pardon me, criminal record. So what we've decided to do is to delete from the clause the words, for the purposes of the Criminal Records Rehabilitation of Offenders Act. Delete those words. What it leaves is the rest of the clause, the intent, which says a contravention of this section shall not form a part of the criminal record of the offender. So we're going to retain that part of the clause and simply delete.
Did you discuss?
No, it would have been effective otherwise.
Senator, Minister.
It would have been effective otherwise,
Minister,
but we have agreed
please,
to make it absolutely clear.
No argument here at all. So is Senator Knight satisfied? Did you discuss it with him? Okay. I don't have to put that. I put that with the regular amendments, right? Madam Clerk? Do I have to put that amendment or just put it the regular amendments?
No.
I beg your pardon?
Not finished with 20, Chair. Section 9 is now Section 11.
Okay.
Right?
I will put that proposal when the amendments to the amendments are being taken. Senator Crawford, do you have something to say?
Yes, Chair. I want to make a proposal as it relates to Section 9, which is now Section 11. As is Section 9, subsection 9. As is, it doesn't speak to the initiation of the process. It speaks to the conclusion that having gone to court, a judge can say what is reasonable. That is after the person have been exposed to the expense of getting a lawyer. That's after they have been arrested, if that is the case. That's after all the negatives. It is my opinion, Sir Chair, that there should be some stipulation as to what may be reasonable so as to not lead to the initiation. So therefore, not to have the person endure the cost to get a lawyer if they can afford it, etc. There should be some account. Now, if a person isn't in this set, they can still go to court. But I think that something should be there to say what's reasonable.
Make a proposal, please.
I'll leave that to the legal.
No, what I understand the minister to have said is that our Senator Charles, I think it was, that reasonable excuse is something that is established in the law.
Yes, sir. But my point
is, what you want is a list of reasonable excuses.
Because
okay.
Chair, let me just make it clear. Senator Braham suggested that the width or the breadth allows for the court, but it doesn't prevent the initiation. And that initiation is an inconvenience for things that are likely to be seen as reasonable. So if it is that religion is reasonable, it is after I've been exposed to court and the cost of it that a judge may say, yes, this house can say these things are perceived to be reasonable.
So you want me to put it that you want me to put your amendment to the effect that this house provides a list of things that you consider reasonable?
Yes, Chair.
Okay.
Yes, a schedule. Yes,
Mr.
yes,
Chairman.
within the schedule.
No, but Mr. Charles,
but that itself would be unreasonable.
Chairman.
That itself would be unreasonable.
How is it unreasonable?
Look here, that's fine. Hang on, please. It's not a question. We don't have to argue it every point. The member is saying that we put in the legislation a list of things considered reasonable. No, sir? Is that I understand it? The question is, Senator Wolano, the question is that included in this, or that clause, let me just get it right, that clause 12.9 be amended, 29, sorry, thanks. Clause 29 be amended to affix a list of things that are contemplated as being reasonable. Those in favor?
Chairman, the challenge I have with that is that once you start putting a list there, then I can say...
So, Senator Gale, vote against it then if that's your problem. I don't need to have your statement. So those in favor of putting a list in section 29, those in favor? Against? The noes have it.
Mr. Chairman. Mr. Chairman.
Senator Morris.
I know you had put the Senator Crawford. I know you had put the proposed amendment by Senator Fraser Binns before, as it relates to getting the timetable in the bill. And just thinking, Mr. President, Mr. Chairman, if you may, I can tell you members, it is going to be very difficult to register persons with disabilities. The experience that we have had over the, in terms of the disability registry, informs me of that, in the sense that only 30,000 persons with disabilities we have had coming on board to register, and we have been doing this since 2012, over a 5-year period. And it's because of the peculiarities, it's because of the challenges that confronts the group, and I believe that we will have to have in place a schedule of implementation, and I believe that we should really consider inserting in the bill a timetable for implementation, because it is going to be really challenging, I can tell you, Minister.
As the President is in conference, I will just respond to say that this is an issue that we have considered, and as I was explaining earlier, that it's a very difficulties that you express why it is that we are changing, and it's one of the benefits of the NIDS and the process, which will include the support to ensure that persons with disabilities are registered. So we will have a rollout program. Notices will be given to the public. Schedules will be done island-wide based on the particular locations and communities. This is all coming, but that's part of the operational side of things. It's not something that's included in the bill. And just to address the argument that had been raised by Senator Fraser Binns earlier, the pensions bill was actually amended to take out each and every appointed day that had originally been included, because what had happened was that the debate kept being postponed for further consultations, which caused the bills to become out of date, and the dates had to be amended. So we amended all straight through the pensions bill in order to say that it will be on the day appointed by the minister. And so that is, and that was as concrete and recent an example of why it is not appropriate to put dates in the bill. So our position on that requested amendment still stands, even though I don't think you can put an amendment twice. I was just using the time, Mr. President, as you weren't speaking.
I'm certain that a couple months down the road, you're going to see the merits of this proposal, because I tell you, Minister, I tell you, Minister, it is being proposed to assist this bill, because I don't have as much confidence as you have in some of the individuals who will be charged to implement the system.
Thank you, Senator Morris. A word of warning, Minister. I'm going to put the amendment to the
Chairman,
amendments.
I still have some contention with Clause 20. Please forgive me. I do have more contention with Clause 20.
No, I don't want Senator Fraser-Baines, with the greatest of respect, if you have an amendment, put it for me. I know that you have concerns about it, but if there's an amendment, put it, or rather than just telling us what your concerns are.
Yes, sir, but you will also appreciate that sometimes you need clarity. Even though they were raised in the debate, the minister did not speak to all the issues raised. So I'm going to ask you kindly to bear with us as we take our time and go through this bill. Minister,
Let me explain something to you now. Let me explain something to you. I have as much time, you know, but I'm sticking to the rules of this House, of this Senate, that says that identifies. No, man, Senator Brown, that's not true. You can say anything you want to say, and you do. But if you have a suggestion for or whatever.
Thank you, Mr. President, and I will take your guidance, sir. Minister, Clause 20, subsections 2 and 3, I did raise it in the debate, where it speaks to the authority taking such steps as are necessary. And I see that at 2, I see that at 3, I see that at 6. And I am asking you, before I make a recommendation, I'm asking if you could just help me to understand when you say such steps as are necessary, what exactly is meant by that?
While that is somewhat difficult to enumerate because the breadth is why the clause has been stated, the possible things that the authority may have to do. For example, the provision of a free birth certificate because the person doesn't have a birth certificate in order to enroll. We will facilitate that. Those are necessary steps, such as certifying a disabled person as with the particular disability that they have. We will do that. These two clauses authorize the authority to ensure that persons are enrolled notwithstanding their particular circumstances. That is why it is stated so broadly, because the possible permutations and combinations that a person may require is impossible to enumerate effectively in the bill, and that is why it will remain as it is.
Thank you, Minister. You have concluded before you've heard my part 2. Subsection 6, for example, says the authority shall take such steps as are necessary to satisfy itself as to the accuracy of the information provided by the individual. Now, Minister, I am very uncomfortable with that. Somewhere else in the bill, we talk about such lawful step. This one is not qualified. So is it that the authority can wiretap? Is that it can go and investigate my neighbor, can go into my bank account? I don't know. I am asking you, Minister, through you, Mr. Chairman, I am asking you kindly to help us to understand, especially at subsection 6, what is meant by such steps as are necessary to satisfy itself as to the accuracy of the information. You may know Senator Sinclair, but not everybody knows.
Chairman,
Mr.
Sorry, Senator Knight. Let me just hear from Senator Sinclair.
I am a bit taken aback.
Let me hear from Senator Sinclair.
Somebody with legal training, because it doesn't derogate from any other law, Mr. Chairman. It doesn't derogate from any other law. You have the Constitution. You still have other laws that deal with the issues.
Let him finish now.
The issues to which you spoke. there are laws that deal with that, including the Constitution, and this obviously does not derogate from that.
Right, Senator Fraser-Binns, Senator Knight, you want to say something on this?
The question, the inquiry being raised by Senator Fraser-Binns is not as wild as some may think it is, because that inquiry, as I understand it, is raised in the context of the invasive nature of this bill. And therefore, if it is, as I understand her, that the authority is given this unbridled right, then their invasive powers are the more so evident. And therefore, what she's saying is, this has to be circumscribed in some way. Otherwise, the authority is at large. So it is not a simple matter. And I don't think it has anything to do with legal training, because many persons who have complained about it have absolutely no legal training. But they have an understanding of the right to privacy of a citizen. And so I take it that having raised it in that context, it is necessary for the League of Government Business to respond in that context.
Tonight, what your suggestion is that it says, take all lawful steps.
I have not made a suggestion as to how it should be worded. What I am doing is pointing out the problem. And in this regard, I must confess, I can't be a problem solver in this regard.
Thank you very much. Minister, you intend to make any change here? Minister, you intend to make any change in this?
Before the leader responds, if we insert lawful steps to mirror another provision in the bill, which I cannot immediately recall at what clause it is, would that do any harm? But it would, in fact, it would strengthen it, because I think if we already have it somewhere else, that it should be lawful. Oh.
But Chairman, could it be speaking to unlawful steps? Could it in any way, in the principle of stare decisis, is it our common law with judicial precedent, be speaking to anything other than steps?
The Parliament must understand that there are authorities and persons who act outside of the law to the prejudice of the citizen. And therefore, whilst it is that we would expect the authority to do only that which is lawful, we should also understand that they don't always act that way.
But that is why we have.
Okay.
That's why we have the court.
Take some, Minister.
Thank you for the time, Mr. President. So we have heard the Senator Fraser-Binns' concerns and have looked at the issue. But the point is, Senator Fraser-Binns, that there is a presumption in law, a presumption in administrative law, which grounds the understanding that an authority will act in a lawful manner. So that the drafting of our legislation, our legislative scheme and framework presumes that. So if we start to include legal law, the qualification of lawful, it will not only be inconsistent with other laws, and internally we would have to make several other amendments as well. But it is inconsistent with our legal interpretation framework. The presumption exists in law, so it is not required for this clause. The difference is with the other clause that you made reference to, which is about using lawful means to verify information, is a little different than the general provision of the authority taking such steps as may be necessary in order to ensure enrollment. So we will not accept that amendment, Mr. President. It's inconsistent with our legal framework.
Could I just ask a question? You're dealing with the accuracy of identity information and demographic information. And so,
Senator Knight, this is a different point?
no, it's a different, it's the same subclause. What causes me a little concern, and my fears can be easily allayed if you seek so to do. An authority breaches the law in terms of going into premises without the necessary warrant and so on. In the circumstances here, would the authority be open to legal action? Because there is a clause which says that they are not open to legal action in a number of circumstances. I can't remember exactly now. In other words, if there is a breach here, is there redress? That's all I ask. And I ask the leader of government business. I don't ask anybody else.
But that doesn't stop anybody else from speaking. I think that for myself, speaking, just looking at the legislation, and it is true that there is a presumption of that you'll act lawfully, presumption of reasonableness. And indeed, if the authority, even though the individuals who constitute the authority may be exempted from legal process, the authority is always liable to legal process, whether it is by review or any other process, to challenge their action. I mean, the minister may not agree with me, but I think I can express my view, and that is my view.
I still want yours, because you can't challenge after the fact, as if someone enters my premises without lawful right. I can't prevent them, they've already done it. So my question is whether there is redress. That's all I ask.
The authority is a body corporate and can be sued, Mr. Senator Knight. Yes.
And
Thank you very much.
In the provisions in the bill which speak to them, to one not being able to sue them, wouldn't apply to a section like this. Is that what you're saying?
there's the usual protection of employees acting in good faith within the provisions, but as Senator Braham has pointed out, the authority itself can be sued for any lawful, unlawful activity. And we can review Clause 56 when we get to that point.
An unlawful activity may be done in good faith. And what the statute speaks to is that if it is done in good faith, then there's no redress. That's what this bill says.
Yes, but that's the personal liability, not the corporate liability.
Chair? No, the distinction is without a difference.
Chair? Chair, before you move on and deny me my right to comment.
So why you open your comment by saying I'm denying your right to talk?
Are you going to deny me my right to say that?
To say what?
What I just said. Because I'm going to say it again.
I'm going
before
to
you
put
deny me my right
put in the
to
amendments.
Mr. Chairman, I wish to indicate...
Can I say something? The only good thing is that the whole of Jamaica have the capacity to see what is happening. Everybody can see it.
So why are you concerned about what I said?
You open your statement by saying, am I going to deny your rights? Why would you say something like that? That is a platform that you are looking at. I'm not going to give you, so talk and say anything you want to say.
Mr. President, I suspect we're delaying the process by not allowing me to speak now. What I want to say, Mr. President, in respect to Clause 26, it must be read in conjunction with Clause 6.2f, which says that they are in performing the functions specified in subsection 1, the authority may, at F, do anything or enter into any arrangement which, in the opinion of the authority, is necessary to ensure the proper performance of its function. And when you put that with this thing about taking such steps, that's not different from doing anything. And anything could be unlawful. In your opinion. Right? Which we are now.
Senator Brown.
And therefore I'm proposing that the word lawful, as in 2016, being, as was proposed by the Senator Fraser Binns, be by the opposition leader in the Senate, be inserted after the word such and before steps, that such lawful steps, because I'm scared of the authority being allowed to do anything and enter into any arrangement
personally,
which
Senator
might
Brown,
undermine the rights of the citizens of our country.
I hear you, so I'm going to put your proposed amendment. Those in favor? Against? The noes have it. I'm going to put the amendments to Section 20. Those in favor? The amendments to Section 20. Those in favor? Against? I'm going to put Section 20 as amended. You're dividing on the amendments?
Respectfully, Chair, you do recall that there was an amendment which had been agreed.
It's in. You're dividing on the amendment on that vote?
No, I had not.
Okay.
I was not aware.
So
I thought
I'm putting
we had
Section
deferred
20
it.
as amended. Those in favor? I'm putting Section 20 as amended. Those in favor? Against? The ayes have it.
Senator Braham, Senator Braham, Senator Brown, Senator Charles, Senator Crawford, started it the wrong way. I'm doing it ayes and noes. The ayes have it. It says you're answering aye. Okay. Senator Braham, Senator Brown? Senator Charles? Senator Crawford? Senator Fraser-Binns? Senator Gale? Senator Hill? Senator Johnson-Smith? Senator Knight? Senator Longmore? Senator Morris? Senator Morrison? Senator Reid? Senator Samuda? Senator Scott Motley? Senator Sinclair? Senator Skeffrey? Senator Slowly? Senator Webby? Senator Williams?
I do report the result of the divide. Ayes 11, noes 8. The ayes have it.
There's no amendment proposed to Clause 21, Mr. President.
Mr. Chairman.
I have a, sorry, go ahead, Sophia. Why is Section 21 phrase subject to subsections?
Sorry, Senator Knight. Cancellation of enrollment. Senator Morris? Cancellation of enrollment. Clause 21. Cancellation of enrollment.
That's the heading for the section.
That's the heading.
That we discussed earlier.
Just repeat,
yes.
Yes. Subject to subsection. Why does it mean subject to subsections 3 and 4? Because subsection 1, A, B, and C set out very clearly the circumstances under which the discretion to cancel can be exercised. Subsection 3 sets out very clearly that where it is proposed to cancel, the authority must do certain things. And 4, it sets out the discretion the authority has in the particular circumstance. So, the cancellation is not really subject to 3 and 4. 3 and 4 impose a duty on the authority. It sets out the right, and then it sets out the duty. So I'm not sure that it's subject to. You know? You following me?
I follow you totally, but I don't necessarily agree. Because it's somewhat stylistic. I think the intention of the draftsperson was to emphasize, for absolute clarity, that the authority of the that the power of the authority to cancel the enrollment in these circumstances is circumscribed by 3 and 4, such that where they propose, they must do these things, inform, etc. And that 4.
3 and 4, yeah.
So
3,
yes,
in other words, they can do A, B, and C, right? When you do A, B, and C, when you propose to do No, what I'm saying is that they may cancel the enrollment for these reasons, A, B, and C. That's a right. They exercise their discretion. having, so 3 now says, where the authority proposes to do that, they are to do certain things. So it's not really dependent on our subject to. It's not dependent on our subject to. 3 is a consequence of the discretion. So I don't know.
Minister, I'm
Sorry.
President.
All right.
President.
Okay. If
President.
No, let me finish, Mr. Man.
Senator Knight, let's let Mr. Brown.
No, but
maybe he can shed
there
some.
it is.
Senator Knight, go ahead.
If it is, you are saying, Minister, it is simply stylistic, then I won't pursue it.
Okay, so I put section.
Mr. Chairman, Mr. Chairman, I would like to draw the minister's attention to subsection 3 that speaks to appeal. And
which section?
Subsection 3, 21 subsection 3 on page 18.
Yes.
Firstly, I wish to find out in the circumstances whether the appeal would act as a stay for the cancellation. That's the first thing. And if it does, then I would recommend that a section be inserted to state that where the registrable individual appeals the decision, then the authority would not suspend until after the hearing, after determination. They can phrase it properly.
The intended operation of the clause is that when the appeal is made, or rather, the card remains valid, the NIN remains valid until the card is actually cancelled. And a decision will not be taken to cancel the card until the provisions, including for appeal, have been exhausted. So a decision will only be taken. So
the cancellation will take effect after the appeal.
A decision has been taken on the appeal, exactly.
Minister,
so,
for certainty, could you state that? Because it's not clear here at all on the reading of the bill. It really isn't clear. And I'm just asking you to, you can speak with the technical team, but I'm asking you to consider inserting something. Perhaps we need to rephrase subsection 3 to state that expressly. Talk to Sinclair. Talk to Sinclair.
And Chairman, while the Minister wishes to clarify, okay. Minister, before you clarify, I don't want you to walk twice. I want you to consider.
Appeal is fundamental.
I want you to consider at 21.3 that the authority shall so inform the individual in writing. I wish to suggest are other means of communication that the person could understand. This is going to cover everybody. It couldn't cover somebody who is blind, who may understand Braille. So could we make it clear that we want to be inclusive, sir? So we believe that it should be inclusive, and those are language that we could.
To see if the definition of writing as it stands would be sufficient or whether regulations will be sufficient to translate that operationally.
Yes.
Listen, man, I don't know. Why are you interrupting us?
Mr. President, thank you for the time. I'm hoping Senator Fraser-Binns is particularly passionate about this point. But there. I wanted to address the point raised by Senator Brown, which was asking for the notification to be in writing or other such means. And the guidance is that this is a normal formulation, and it is in fact the formulation, for example, that you requested in JACRA and that we made, and that it is all subject to Clause 6, which actually sets out the fact that the authority must ensure that it takes into consideration systems and procedures which allow for ease and convenience in the enrollment of individuals, which does provide for a general requirement that its processes are broader. So writing is a general as defined in the Interpretation Act, and then they have a duty, however, to ensure that their systems and procedures are designed for ease and convenience.
Normal is pre-Disability Act. Normal is a time when we never have regard for the diversity that the society strives for. And it's for that reason why I believe we should put it there so that we're...
No, sorry, but this will help you, I promise. Because in later on, sorry I didn't read, in 6.5, it specifically says that in the performance of its functions, the authority shall have regard to the needs of persons with disabilities within the meaning of Section 2 of the Disabilities Act. That was what I was looking for and hadn't reached there in time. So it is in everything that they do, and in all, this is 6.5, Senator Morris, 6.5 of the bill. Yes, 6.5 of the bill. So it is expressed that in everything they do,
this is so
in
general.
Performance of its functions. It's not, it's
well,
overarching.
it is so general that we in the Senate didn't have regard for the needs of one among us who needed a special attention last week. And if we in the Senate can treat one of us this way, then the 300,000 people out there with disability demand that the 21 of us insist that it be in the legislation in a specific way.
But it is by way of 6.5.
That's what we want. But
It's by way of 6.5.
No,
it is an absolute obligation on the authority in everything that it does.
You know, there is legislation which says we must communicate to people in ways that they understand.
So, Mr. President, the proposal for the amendment has not been agreed. So if you could put the clause.
That's part of the thing we have a difficulty.
I will put Section 21.
No, Mr. President.
No, Mr. President.
Mr. President.
I put Section 21.
The matter of the disability communities.
As I understand what the minister is saying, it is covered in the legislation.
Well, I don't accept
so what
that.
What you want to put in it?
I want
Make a proposal.
I've already made one and I repeat it. That in writing or other means of communication.
You want to specify what the other means of communication is?
Other means of forms of communication.
The question is that
the
question is that the section be amended to read in writing or other appropriate means of communication. Those in favor? That is appropriate. Those in favor? Against? The noes have it.
Mr. Chairman.
I'm putting Section 21.
Mr. Chairman, before you put Section...
Mr. Chairman.
Chairman, before you put Section 21, may I make an inquiry of the leader? In section at A, we spoke to a misrepresentation or concealment of information by the individual. You'll recall that we had made certain aspects of the information provided mandatory and some voluntary. My concern is that in not placing identity before information, if somebody lies, for example, or not lies, but conceals or misrepresents their religion this would fall into this category. And I thought that for absolute clarity, relating it to the mandatory section rather than the voluntary section as we had agreed, we could use identity information. That would, yes, because that is how we have actually been expressing it in the bill, both in the amendments we have already taken and those which we have agreed will come.
Mr. Chairman.
I'm not going to preside over that.
Mr. Chairman.
Is there a suggestion for changing? Is there a proposal, an amendment to Section 21? Is there?
No, Mr. Chairman.
Mr. Chairman. Is there a proposed amendment to 21?
Chairman. Mr. Chairman.
Can I hear it?
Chairman, I've proposed that in relation to 21A, that there be, before information, you insert identity information to make sure and absolutely clear that it does not include demographic information, which we have agreed will be voluntary.
Be consistent with the bill. That's why I would say I should take a break. Take a break. Minister is getting confused. Not ready.
But Mr. Chairman, Mr. Chairman.
Represents the nature of the bill, how they behave.
Mr. Chairman. Mr. Chairman. No.
All the responsible people on this side.
Yes, but not demographic.
What?
Because we have there.
What? We are on a break, Mr. Chairman? Mr. Chairman, are we on a break?
The minister is confused. It is not chronic. I promote it right now.
Mr. Chairman.
I wait my turn.
Look here, we have been at this now for an hour and a half, Section 21.
And I have been trying to get your attention for the past 20 minutes.
Do you have a proposed amendment?
No, Mr. Chairman, it's an observation that I want to make.
I don't want an observation now, with the greatest of respect. I think that the leader has put forward an amendment in relation to there was misrepresentation or concealment of identity information. 21A. Fine. So we're accepting that.
Yeah.
There was a misrepresentation or concealment of identity information by the minister. That has been accepted, I'm sorry, by the individual. That has been accepted by the minister, so I put the amendment to clause 21. Those in favor? Against? The ayes have it. I put clause 21 as amended. Those in favor? Against? The ayes have it. I'm on clause 22. National identification number, non-conferral of citizenship or domicile.
Amendment.
Any amendment, Minister?
There's no amendment to this clause, Mr. President.
Clause 22. Those in favor? Against? Ayes have it. Clause 23. There is an amendment. I note on the amendment sheet, page 6.
Yes, sir. And Mr. President, just for Senator Morris, this part is Part 5, National Identification Number.
So I put the amendment to clause 23. Those in favor? Against? Ayes have it. Clause 24. There's an amendment which begins on page 6. And I'm sorry, it's actually... Sorry, Mr.
Recommittal of 20...
Senator Brown.
23...
Senator Brown, I'm not going to do that now.
I'm asking for a recommittal of 23. Are you going to do it later? Because there's an issue here that I wish to raise and to make a proposal.
Just leave it. Why not?
All right.
Where am I?
23, I'm seeking recommittal on.
I'm at 24.
Because my concern...
So, Senator Brown, address me about that in a while. I'm at clause 24, and there are amendments, or there is an amendment.
But there may be consequential issues arising from the 23.
Well, when the consequential issue arises, raise it. I'm on. My college mate from Jamaica College.
Yes.
The amendment.
I wanted to insist that a time frame after giving information for the issuing of these IDs.
There's an amendment to clause 24 on page 6. Do I put the amendment to place to clause 24. Those in favor? Against? Ayes have it. I put clause 24 as amended. Those in favor? Ayes have it. Clause 25, there is an amendment on the beginning of the page 7. 25, it's eligibility for issue of national identification card, and there is an amendment to it. I put the amendment. Those in favor? Against? Ayes have it. I put clause 25 as amended. In favor? Against? Ayes have it. Clause 26 on page 7 of the amendment sheet, there is an amendment. And I put the amendments.
And I wish to propose another amendment.
1 minute, please. It's entitled Renewal of National Identification Card. 26. Senator Brown, you had something to say?
Yes, sir. And it's connected to a point I wanted to make at 23.
Okay.
There is no timeline after I give my information. The citizen gives their information for the verification process to take place. And we believe that if the government demands of the citizens that they should give this information, there ought to be a timeline in which the verification takes place and the citizen be presented with such a card. And it's not here, and I believe that the legislation should contain that. So my proposal is that there should be a timeline.
The inclusion of a timeline here.
Mr. President, it would be inappropriate for the legislative process. It's something that should be included in the regulations that deal with the operational side and the standards of performance.
Okay. Senator Brown, satisfied with that? I put the majority. I put the amendment to clause 26. Those in favor? Against? The ayes have it. I put clause 26 as amended. I put clause 26 as amended. The ayes have it. I have to hear this, you know. You get the picture? Senator Brown? 27, Minister, any amendment to 27?
There are no amendments to clause 27, Mr. President.
Thank you. I put clause... Senator?
Yeah. It says the ID, which I shall display in request by a private sector entity, is only prima facie proof, and therefore this great ID can, sir?
Direct me to, tell me what you're saying. Direct me here.
Page 19. Are you at page 19?
Yeah.
27, 2?
2.
Yes. What this saying is that ID, in the absence, shall be prima facie proof, which means that when I go to buy gas or I go to Isla to buy my bread, they can challenge my ID. And the law now, as it stands, the bill as it stands, compels me to give them my ID. But it doesn't compel them. It does, let me talk now, because I'm not going to muzzle me today now. The bill compels me at 41-2.
Look here, I don't want Senator Brown to feel that he's being muzzled. So, Senator Brown, if you have an amendment, it says, as I see it, shall be prima facie proof, which means that on the face of it, it is proof of your identification, subject to something else being established.
For 42-2, I'm in regard for 42-2 and 41-1 of the bill, which compel the citizen to produce the ID. There is no requirement for the public body or the private sector entity to accept the card, because they can, because it's on the prima facie, says there's a presumption that I am a crook, or the citizens are crook, or the ID not valid. And so what I'm asking for is that it goes beyond the prima facie, that it be accepted unless there is evidence. No. It says here, go right. In the absence of evidence to the contrary, shall be prima facie proof. But it means that they have an assumption. They can challenge it. And what I am saying, it must be accepted.
Thank you, Senator Brown. So your amendment is that wherever the identification card is presented, it must be accepted
unless there is evidence.
But that's what prima facie mean.
No.
Because in the absence of evidence to the contrary shall be prima facie proof of the particulars contained in it, and that's exactly what it said. Exactly what you said in.
Mr. President, I'm continuing my position. A national ID
Senator Brown,
card,
just tell me what the amendment is that you want.
I am saying, I don't care what I want to say, because they make so much bad laws, right? My concern is that if I am compelled to give the private sector my card, it must be clear, not in Latin, that they must accept it unless they have a reason.
That's what it says.
Let me finish now, sir. Because that's what I talk about Muslim, you know.
No, let me tell you something. There is a question of presiding and not involving myself in the discourse. But what is here is exactly what the member is saying. So if there, sorry, leader, if there is a proposal to put it.
Chairman, the use of the word prima facie is in fact superfluous in this context, because it says unless there's proof to the contrary, unless there is, I don't want to misread it, but it already says unless there is something to the contrary. And if you deleted the prima facie, it is supposed to be proof. The prima facie, the prima facie is superfluous to the whole intent, because you already said unless there's proof to the contrary. I must confess that at first when Senator Brown raised this point, I did not comprehend what he meant, but when he was allowed to proceed, it is clear that you don't need prima facie. In fact, it does more harm to the section that it advances it.
And that's what we're trying to get, but the nice makers who don't understand.
Because the absence of evidence to the contrary.
Mr. President, Mr. Chairman, when I want to talk to you, I face you, and tell you what I think is those who are not.
Mr. Chairman, stay with me for a moment, Mr. Chairman. In the absence of evidence to the contrary, it shall be proof of the particulars contained, is what I am proposing.
The fact is that prima facie phrase, prima facie I usually say, but clearly there are more eloquent pronunciations, makes it clear that on the face of the card, that this is what should be understood, that on the face of the card, unless there's evidence to the contrary. So we don't think there's any harm done by the clause as it is, and if there's an amendment to be put, we'll consider it. If there is not, sir, I would ask that you put the clause.
So I will make an amendment.
So the amendment, the proposal is to remove prima facie. You want to put
proposal is to remove that, because it should be absolute proof, unless there is evidence to the contrary.
The question is
proof
in
of
relation
your identity.
to...
That's what you're all doing.
The question is that section 27(2) be amended to remove the words prima facie. Those in favor? Against? Noes have it.
Mr. President.
I put section 27.
Mr. President.
Yes,
section 27(3). It speaks to some specific information as to the size, description, and content for the card. And it says may be specified in regulation. I think this is critical issue. No, let me finish the point. You people not listening. may be specified in the regulations. Regulations. Yeah, man. Yeah. The question I'm asking, critical information like this, I think cannot be just left. No, don't finish it to me. Mr. Chair, may I make my point, Mr. Chair, please?
You shall make.
No, I don't need an interpreter, Mr. Chair. May I make my point, please? Yes, please allow me. Critical information like this should not left to the discretion of the authority to be included in a regulation, but must be so specified. So the citizens will have the exact content, description, and so on. So it should be included, hence replace may with shall. Thank you, Mr. Chair.
Question is that the word may be replaced with shall. Those in favor? Against? The noes have it.
Mr. Chairman, that's a point of clarification that I need. Because this bill will go back to the House of Representatives, right? Mr. Chairman?
Yes.
It will go back to the, all right. So I can't understand then, Mr. Chairman, why is it that we are here to review the legislation, but when practical, reasonable suggestions are being made, the government is using its majority to oppose and override those suggestions?
Okay. That's an observation which I take on board. But at the same time, it is not a correct or fair assumption to make that one side is voting in a particular way because of something and the other side is not. So let us see it. Let us watch the democracy at work. Those in favor, and Senator Morris, you have been here, you have sat right in this chair, so you know exactly what the situation is. I put clause 27. Those
Mr.
in
Chairman,
favor?
I said reasonable,
against,
practical suggestions.
The ayes have it. Clause 28. Any amendment? No amendment. Use of national identification card 28. I put clause 28.
I did indicate you're not hearing me, President.
Go ahead, man.
28 says, a national ID card may be used by a registered individual as a means of proving the registered individual's identity, as the individual may require. What does this mean in light of 27.2? No, 27.2, which says that when I present this ID, it doesn't even say I shall be used as a marriage, it shall be used, it may be used. But in 41 and 42, I shall present it. So this is a bill that is so much against the people, against the citizen. It is for the private sector. It is for the public body. It provides for them compulsion of the citizen. But when the citizen produce the ID, there's no compulsion, there's no acceptance of it. It's not absolutely required. And so again, I'm proposing that the may becomes shall at 28 and that we defend the citizens. We defend the citizens of this country and don't sell them out. We're selling them out for $68 million loan US.
Senator
and we're
Brown.
selling them out again
Senator
with
Brown.
this legislation.
Senator Brown, you have an amendment proposed?
I just did.
I put Senator Brown's proposal. Those in favor?
What is that proposal, sir?
What?
What is the proposal you put in?
You know it, don't it?
No, but I want to be
I'm
clear.
asking you if you know what it is.
Yes, I know.
So I put
clear.
Senator Brown's proposal.
No,
Those
what
in
is that
favor?
proposal?
Mr. Chair, you need to put the proposal.
Senator Brown, you don't know your own proposal.
Answer's sake, you need to repeat the proposal.
Having forgotten what I said, to be hiding under the fact that I don't know what my own proposal is, I'm ashamed of you, Mr. President. Such game, you may play it elsewhere. But with somebody like me,
Mr. Chairman,
I propose that may become shall.
Mr. Chairman.
You may know.
The question is that the maybe shall become shall. Those in favor?
It's been sufficiently ventilated.
Ayes have it. The noes have it. So, but section 28 it's a clear thing, and I'm putting section 28. Those in favor? Clause 28. Those in favor? Against? Ayes have it. Clause 29. There is an amendment proposed on page 7 of the sheet. Clause 29.
Mr. President, if you could put the amendment.
I'm beginning to sound like President Morris.
Chairman, I don't think the government members understand the import of section 28. I don't think they understand the import.
Minister, you have an amendment to section 29?
The amendment is set out on page 7 of the list, Mr. President.
The amendment of 29, which is contained on page 27. Those in favor? Aye. Against? Ayes have it. I put clause 29 as amended. Those in favor? Aye. Against? Ayes have it. Clause 30.
Chairman, with
yes.
due respect, because you put forward an amendment on page 27, which is on page 7. By the time I find page 7, the ayes have it. That can't be.
No, just if you follow me, you realize it's page 7. If you follow me,
Page
you'll be all
27,
right.
and I was searching for 27. Jesus Christ.
Mr. President, there are no amendments from clause 30 to 33.
I put clause 30, to which there are no amendments. I put clause that says a national identification card remains the property of the authority. You have an amendment to that? Put the amendment, please.
Yes. Mr. President, I will recall that a passport remains the property of the government of Jamaica. To see at 30 that notwithstanding the ID being the property of the authority, the citizen cannot be deprived of it, just as in the Charter of Rights now passport, cannot be deprived of it unless through a judicial decision. And I think it's important, since this ID will be like a chain around the citizen's neck, where they will have to carry it everywhere, then it shouldn't be allowed to be taken from them without judicial status. So I'm asking that this ID be given the same status in the Charter as the passport have in the Charter of Rights.
So I'm going to put section clause 30.
30.
What you want to say, this national identification card.
Notwithstanding that this ID is a property of the authority, it shall not be taken away from a citizen unless by a judicial decision.
You have heard the proposed amendment. Those in favor? Aye. Against? Noes have it. I put clause 30. Those in favor?
No.
Sorry, Senator Knight. You have something to say.
I put an alternative. A national identification card remains the property of the authority. However, it shall not be taken without due process. Aye.
Divide.
We can do a chorus.
Divide.
Aye. No.
Let me just ask, why are you against that?
I'm
Can you tell me? Why are you against it? Tell me why. I have. I can't hear you.
Senator Graham?
No. What? Before the divide, I asked, why are you against it? Why are
Senator Knight, with the greatest of respect, you're asking the leader a question. She has indicated that she's not changing the clause. There are no amendments.
No. I need to know because if she
Madam Clerk, there is a divide. Would you please call for the numbers?
No, hold on. Let me tell you now.
Senator Brown?
I really now
Senator Brown?
find it ridiculous, both by the action of the denial of
Senator Brown?
the opportunity to hear from the leader. Chairman,
Senator Knight, there was a vote, there's a call for a divide. I'm trying to take the divide. Madam Clerk,
before
take the divide?
call for divide, I asked. I made an intervention. So you can't say what he's granting and not granting. Before I asked, tell me why. What are we trying to do here? Are we trying to develop a better bill, or are we just showing off our majority? If we're just showing off the majority, go ahead.
That's what you're doing. Because I hear a chorus. I hear a chorus.
The chorus. Senator, Madam Clerk, would you take the divide, please?
If you're just showing off the majority, I'm going to tell you something. These majorities are temporary. Understand that. Your arrogance is not going unnoticed. Your arrogance is not going unnoticed.
Senator Knight, please,
I want to tell you something else.
Senator Knight.
After all, listener is going back downstairs, and it might come back up here. You understand me? So understand process. And I really take exception to this, because there is no desire to at all have this matter resolved in a reasonable way.
Senator Knight, I'm trying to take the divide that was called for. Madam Clerk, please go ahead.
I'm now satisfied that you can.
Go ahead. And then there's laughter. Would you please concentrate on the people's work? Go ahead, please, Madam Clerk.
Senator Brown? Senator Brown? Senator Charles? Senator Crawford? Senator Crawford? Senator Fraser Binns? Senator Gale? Senator Hill? Senator Johnson Smith? Senator Knight? Senator Knight? Senator Longmore, Senator Morris.
No, it's not going to be denied. I have a right to explain why I am voting in a particular way.
Well, would that be extended to me, sir, every time I wish to vote?
Everybody!
I'm not aware of any right in the standing order that allows. I am not aware, President, and Senator Knight, of course, may show it to us, where every person, before they vote, have a right to explain why they are going to vote in a certain way. Chairman, if you would bring it to my attention, I would be able to
not responsible for you.
Otherwise, President, every time I vote, I demand a right to explain why I'm going to vote in a certain way.
I'm going to ask the clerk to continue with the debate.
No, I have a right to explain.
Senator Knight,
I am explaining my vote.
Tell me where it is in the standing.
I can't recall the particular number, but that right exists.
Not there.
I am explaining my vote.
Please.
My vote is given because, as in the circumstances of a passport, the passport cannot be withdrawn without due process. And that is why I am voting yes for this amendment.
Thank you, Senator Knight. Continue,
Senator
please.
Morris.
Nobody going to deny me my right in here. And I am not responsible for anybody's particular density.
No.
Senator Reid. Senator Samuda. Senator Samuda.
Senator Samuda, the clerk is talking to you.
I don't know, I can't hear you. Senator Scott Motley. Senator Sinclair. Senator Skeffrey. Senator Slowly. Senator Webby. Senator Williams. Senator Williams. Senator Williams.
Ayes 8, noes 11. And I put clause 30. Those in favor? Against? Ayes have it. I put clause 31, to which there are no amendments. Those in favor? Against? The ayes have it. I put clause 32. Those in favor? Against? The ayes have it. I put clause 33, to which there are no amendments. Those in favor? Against? The ayes have it. There are amendments to clause 34 on page 7, and I put the amendments. Those in favor? Go ahead, please.
Wish to recommend that the same amendment that we all agreed to at clause 21 relative to identity information, that it be carried through at clause 34.
The card, and that was about enrollment, which is two different things. So I think this is fine as it is, because this is all that will be reflected. This is all that will be related to the card. Your demographic information is captured as statistical information. It's only going to be identity information that is relevant to your national card. So the clause operates differently from the one that we amended.
All right, so I put, sorry. Go ahead, Senator Brown.
Does this mean that if a citizen changes
34, 1A.
1A, yes.
You said 33, you know.
Sorry, my apologies. 33 doesn't have a 1.
There you go. That was one. Then where you are going?
That's where I'm the same page and the same number. 34, 1A. Would a change of address or a change of phone number
President, the reading. President, the clause says that the authority may cancel a national identification card if it is satisfied, A, that the national identification card was issued, President, based on inaccurate or incomplete information. So that if I am living at 34 Duke Street when it was issued, and that's where I'm living, it is accurate. If I'm now living at 60 King Street 10 years later, that doesn't make that information given earlier inaccurate, sir? Not at all. So I don't understand the question. But other persons over there said that it is due to density.
You see, Mr. President, there's a verification process. And unlike Senator Braham, who will reside at the same place for 10 years, there are poor people in Jamaica who will move between the time the enrollment took place and when the card is to be issued. It is not for the people who are rich like Senator Braham that I am concerned. It is for the poor people.
I spoke to you about calling me rich and so on, so on. I am no more rich than you.
It is you who tell us that you will stay there for 10 years. I know poor people move regularly because for one reason or another. It is them. It is they that I am concerned about.
So you don't know much about poor people.
And so I'm trying to clarify, not from Senator Braham, but from the minister, whether or not that would count
Chairman,
for grounds for cancellation.
Chairman, I'm saying that the reading, the very words themselves in normal and regular English say what it means. Yes. That's all I'm saying.
And that's what he has said.
Mr. President, can't say anything.
Senator Brown,
I'm saying the question is unnecessary.
I don't understand you because words can't say what it means. That's why I don't understand you.
Mr. President, such, however, at 34.1a, however, demographics information.
Senator Brown, go ahead now, please.
Arising from a change in the data would not be grounds for cancellation of the card. That's at 34.1a.
So there is a proposal put forward by Senator Brown, and you all heard it? Did you hear it? Those in favor?
Aye.
Against?
No. Right, go ahead, Claude.
Aye. Yes, Chairman. 1A. Yes, 34A.
Senator Brown, the mic.
Chair, while I understand the simple English and the difference between was, there's also an obligation caught somewhere here in the bill that there must be corrections made by the individual if circumstances have changed. How is that reflected and treated here if circumstances change?
It's not that it just says was. It says that it was issued based on inaccurate information. So, as Senator Braham just explained, if the information was accurate at the time the card was issued, that is when you were applied for the card, then it's fine.
But if you gave me an opportunity to finish, I was saying that equally in the same bill, it stated that the individual had an obligation to update. Now, give me a chance now, may I beg you? I mean, in as much as there's more of you, I have a right here. That's right. Now, at the point, at the chair.
They vote against my right
yes.
week, so they will vote against your right this week.
No, all I'm saying is this. At the point that a change has been made on the system, the card would reflect something different from what is now on the system. Now, if that is so, the person observing the card would be observing incorrect information as versus what is on the system. My question simply was, how would this be treated? if the card remains valid, even if the information was changed. So that is what I'm saying. Now, the second thing I'm saying now, Chair, is that, well, I would like to understand that part first.
Certainly, it would be useful, and I would imagine that citizens would want their card to be accurate and have its accuracy maintained. So certainly if you change your address, it would be useful for you to update your information at the authority. But it would not make it liable, it would not be that your card would have been liable to revocation based on it having been inaccurate at the time of issue. So it wouldn't affect it. Your card is fine, but you will need to update your information if it is for its own utility.
You finished, Amen? Minister, 34.1a. I heard the explanation and I muzzled and I thought through it, and I'm still not comfortable. I believe that there is no harm to be done if you simply insert identity information. I know you mentioned that the mandatory versus the discretionary, the voluntary information. However, if I choose to put some of the voluntary information and not all of them, is it that my card can be cancelled when your review shows it's incomplete? I believe it's something that you should consider, Minister, and I ask you to consider.
Senator Fraser-Binns, it does no harm, and that we agree that it will add clarity, so we're going to add it. We're going to add it. We're going to add it. That is, this is inaccurate or incomplete identity information. We're going to add it. It would have operated fine without it, but we will take your point regarding out of an abundance of caution.
Mr.
But
Chair,
that will not apply to all.
Mr. Chair, I go to 34.2 on the issue of appeal.
Sorry. So we note that amendment which will be put with the other amendments, right? Because there are amendments to it.
Yeah, Mr. Chair, 2C, the issue of appeal. I can see how while you cancel a person's ID and the person has the right to appeal, it is still not clear here what happens to that ID during the process of the appeal. So I'm proposing that we insert that the national ID card will remain in effect until the appeal is heard. Because if you cancel and I have a right to appeal, there's nothing here to specify what happens during that process. So the ID card remains in effect until the appeal is heard, so you don't penalize the person. So I'm proposing that, and let me hope that the government side will find favor in that recommendation.
That is, in fact, how the clause operates. And when it's the very same issue that was taken by Senator Fraser-Binns earlier, and the explanation stands and applies to this one. So the regulations will set out the process, and it will be quite clear that the card, if the card was to be cancelled immediately without due process, that would have to be stated expressly. How the clause is phrased in terms of what the authority has to do before cancelling, we believe that it is sound in the way
Mr.
it
Chair,
is drafted.
for the abundance of caution.
Your amendment is not accepted.
No, and I'm just asking Mr. Chair for the Minister to do this. For the abundance of caution, what harm would be done just to put that there to ensure that there's absolute. We're speaking about regulations. Right? We have not seen a framework for regulation. And if we say, we put that in the bill as we have it now, what harm will be done?
Senator Skeffrey, you have a proposal or you're just asking the Minister for comment?
The proposal, I just want to put it to the vote, please.
Okay. You have heard Senator Skeffrey's proposed amendment. Those in favor? Aye. Against? No. Ayes have it. So I put the amendments to clause 34. Those in favor? Aye. Against? I put clause 34 as amended. Those in favor? Aye. Against? The ayes have it. Clause 35. There are amendments, Minister.
President, the amendments are listed on page 7, moving on to page 8. It stops at page 8, the base of page 8.
Okay. So I put the amendments to clause...
Mr. Chairman, just give us 30 seconds, please, sir.
There was a duplication with 34 when we merged the concept of cancellation and revocation.
30 seconds is up now, please.
35 A to C is deleted because A to C is already contained in 34. Because it's already addressed in 31A, Senator. It was a duplication when we merged the two concepts. So A to C, which are replicated, 34.1 A to C are the same as 35.1 A to C. It was a drafting error. So A to C in 35 has been deleted. It remains in 34.1. Agreed. No, it would not.
Understand. 35. What is it now? On page 8, where it speaks to, there has been an unauthorized modification of the information in the database in respect of the holder of the card. So, on the amendment, yeah. I was trying to get in my mind this unauthorized modification would arise by virtue of some act on the part of someone in the employment of the authority, or if the database is hacked or so. Is that what this contemplates?
Sure, and so certainly with technology you always have to have some broad provisions in the event of, and that is what this is.
Now, in relation, so for example, if it is found that this unauthorized modification is a result of some act on the part of an employee, is there a section, a clause, which deals with any criminal offense connected to an act like that? Yes. And I see. Okay. Okay, thanks.
Mr. Chairman, Minister, page 7, if we can look at 1E and F as renumbered. Sorry, no, 2, subsection 2 and 3. Can you walk me through, for my own understanding, how... No, Minister, let me tell you why. Let me tell you why, Minister. Okay, let me rephrase that. Clause subsection 2 says, I rephrase it. Subsection 2 says, before cancelling a national ID card under section 1, subsection 1, the authority shall notify the registered individual in writing of the proposed cancellation, stating the reasons for the proposed cancellation and the right of appeal conferred on a subsection 47. Subsection 3 says, where an individual is notified of the cancellation of the national identification card under this section, the individual shall return the card forthwith to the authority. It goes back to the question that I have been asking, that Senator Skeffrey have been asking, in terms of how is this appeal going to work? How do you said it will not, you said the card will not be cancelled until after the appeal, but this section is here. I simply, Minister, want to understand what happens between the notice period and the cancellation. That's all I want to understand. So I'm asking you to walk me through. I don't think that is unreasonable at all.
Those things will be set out in the regulation, as we explained before. What this says here is that where the individual is notified of the cancellation, which is exactly consistent with what we had discussed earlier. The fact that until the appellate process is completed and a decision is taken to cancel, the card operates. It is on the decision to cancel where an individual is notified of the cancellation, then the individual must return the card. It is only on cancellation, not notification of potential cancellation, that that responsibility arises.
So, Minister, all I want to find out, so you are informed that your card will be cancelled. You then have a right to appeal. During that appeal process, you're saying that the card continues to function. At the end of the appeal process, a determination is made. And if the determination is that the card must be cancelled, it is at that point that you return it to the authority. And you then return it. Minister, that is all I'm asking you to walk us through. I don't think that was too much to ask.
But to have walked it through
bill is not about you and I, Minister. It's not about us. It's about everybody else.
I'm quite aware of that, Senator. And I am quite aware of that.
Senator Fraser-Binns, thank you very much.
In fact, I take objection to the imputation that I think it's about us.
Move on.
I think it's about the people.
Arrogance is so
thicker than smoke.
I put section.
Before you do that, Chairman, before you do that, may I just ask for a clarification? If you, Minister, if you look at page 8, right, that sub-clause 2, there's a reference at page 8 of the amendment sheet, number 3. There's a reference to subsection 1H. Is it, just to clarify where that is a reference to, is that a reference to section, clause 47? Clause 47 doesn't have H or E.
No, I believe what it is a reference to, it's above. 1H should have been changed to 1E because the clauses were renumbered. So if on the list we will change 1H to 1E.
Yes, but
right, so except in the case of a cancellation under 1E, as renumbered, of the right of appeal as under 47.
Oh, I see.
Okay.
Thank you very much. Can I put clause 35? Amendments there to those in favor? Aye. Against? Ayes have it. Can I put clause 35 as amended? Those in favor? Aye. Against? Ayes have it. Clause 36.
No, before we go to 36, I'm asking if this is a convenient time, having regard to...
Sorry, Senator Knight, what I have spoken to the clerk, and we had at 20 past, when the time come for the motion, we would contemplate that.
Okay.
I've spoken to Ms. Senator Gale about what I was saying. Just for the purposes of the membership, we have determined that at 1:20 we will take an hour to allow the staff and ourselves to refresh ourselves. That's okay? All in favor of that? Divide? So we are at clause 36. Are there any amendments to clause 36, Minister? There are no amendments to clause 36. No. The impression that I am rushing this? Well, look, if you have that impression, I apologize to you. Look here, make all who have eyes to read and ears to hear. Let them read, observe, and determine whether or not I was speaking the truth. Continue, please, Senator Brown. You have a proposal?
To have it in your possession. No, no.
Senator, let me get an understanding. What this is saying is that if somebody dies, the personal representative has a legal meaning, you know, right? The person shall, as soon as practicable, turn it over to the authority. What do you want to change in that? Every personal representative have a burden. So there is a proposed amendment by Senator Brown. Yes. Those in favor? No. Those in favor? Those against? The noes have it. So can I put
the question, Chairman?
No, sir.
Chairman, the question, there's another question in the sense that the personal representative, so long as we understand, is a very limited category, and I am not sure that most Jamaicans in any event after death end up with a personal representative. But then I don't really know about the poor now. But nevertheless, the personal representative...
But Senator Brown, we dealt with that already, you know, so...
I understand, but there is a slightly different point that the personal representative is a limited category and most persons would not have. And I wondered whether if the person who come in possession of it may not have been a better designation. But I wouldn't agree to delete it. It's useful to have somebody to return. But at the same time, I'm just pointing out that there is a limited category that it deals with.
Okay, thank you very much. Some people are being accused of not thinking through the issue. You all need to pay attention and do the business of the country properly.
I have.
Go ahead, Senator Knight.
On 36 D, where a person comes into possession of a national identification card, one, that has expired, two, that has been, I think revoked has been added.
No, it's cancelled again.
Well, I thought of revoked or cancelled. Oh, that person shall...
You're dealing with this point, Senator Braham?
Consulting chairman. But of course, I suppose it's a bit, anyhow.
Listen, what we're trying to do is help to make better law of the bad even now.
But Senator Braham,
But all is no.
My team vote no against you. Okay, I'm going to say. They're a stop chapter, you know.
His recommendation came from Belmont.
Yeah.
So they'll vote yes for it.
You see,
You just think it's your way. No, for BIT. For BIT. Many
That's when they have
it's a public place, you know.
and they give a team instructions, the same thing. You know, team orders, you guys on a team order.
You see, it remember.
What? I'm not giving you my money for Westwood.
You want to help bail out the free education?
Is that?
Is there a penalty with that?
I deal directly with
Two.
them. I have them on my WhatsApp. I deal directly with them. Myself and Marisol. Myself and Marisol deal directly with them. You should be giving us more. You should be giving us more. You should be giving us more.
You better kick it aside
yeah,
and walk.
I walk
We have
past
done
it.
well without much government assistance.
really,
You should be giving us more.
Minister, while you're taking instructions.
Instructions on the technical people?
Are seeking
I
clarification.
thought it's the government that gives
Is a legal phrase, Mr. Brown?
No, not even in this context it works. Because the lawyers take instructions, not the client. I thought it's government that make the policies. That embarrassing thing this morning. Take instructions. Cabinet decide.
Suppose if I said guidance, you would have preferred that.
Sorry. Yes, Mr. President.
That's a joke.
As we think it's important to keep the provision in because it is important that no person should have should be in possession of the card that belongs to someone else.
Yeah.
But the proposal is to use a formulation that is under the Justice of the Peace Act in respect of the return of seals. So it's really to say, or such other person having charge of the affairs of the deceased, so that it won't necessarily have to be an official legally appointed personal representative, but if there's someone who is managing things for the deceased, they should return it. Or such person having in charge, such person in charge of the affairs of the deceased.
Okay. You had wanted to say something? Senator Knight, you were asking something.
Neither might come in possession of the card, you know. Neither the personal representative nor the you know. But 36(1)(d) leader. Leader 36(1)(d). All there under. Now, if the card has expired, it's of no use. If it has been cancelled, is of no use. If it has been cancelled, it is of no use. It's not of any use. And so why criminalize that? Why criminalize that? Why criminalize it? You know, in other words, let me just tell you straight up. If some persons, if they passed on and I came into possession of the national identification card that has expired, I want to keep it, you know. I keep these things. I have passports and voters ID, all kind of things related to my family. I have them because you're doing no harm. It has expired. You can't use it. It has been cancelled. You can't use it. Yet you are criminalizing keeping it. It don't make sense. Come on. You are criminalizing being in possession of something that has no legal value.
Probably has no legal value, Chairman, but it can become an instrument for fraud. And I suppose,
if it's expired,
information is there and misuse can be made of it, and that could be the mischief. That could be the mischief. I think that Senator Knight should be quiet because at least
Senator Brown was responding to you.
I was speaking. I don't want him to respond to me.
He was silent. No, let me put it this way. Senator Graham is making a contribution to the debate.
He can make a contribution, but let's get...
He's not responding to you, he's making a contribution.
Here.
No, the chairman sets the parameters.
Ask a question...
The chairman sets the parameters.
No, I too do. When I ask a question of the leader, if Senator Graham intervenes, is to give a view, not to answer my question. I'm asking.
But I can give a view.
I am asking.
Senator
I
Knight.
am asking the question of somebody in authority. You're not.
Senator Knight.
You're not. You're being officious.
Thank you very much. Be officious, President.
Minister.
Chairman.
See the time.
Chairman, I cannot be officious if I'm a member of the Senate. And
you
so
have no authority
Chairman,
in relation
be
to
officials and I'm a member
this
of the
bill.
Senate. I'm entitled to speak.
You are entitled
but not to answer my question.
In the meantime,
he has to treat me with the same respect as everybody else.
The Senate to sit again.
Not to answer my question. I asked a leader.
Again?
You're in a leader. You have never been a leader.
I do report progress.
Mr. President.
I tell you that.
Oh, I have to wait. Oh, sorry.
As long as I stand.
Everybody's sleeping today.
Mr. President, might standing orders be suspended to allow the Senate to sit beyond 1:30 to complete the business of the day?
Those in favor?
No, objection.
Against? Against? The ayes have it. I'm going to propose that it's 1:25. I'm going to propose that this sitting be suspended for 1 hour and we return at 25 minutes past 2. Those in favor? Aye. Agreed?
It's a new day.
It's our responsibility to protect our children from harmful TV and radio content.
A and X are no-nos. PG is maybe. G is good to go.
Protect your children and report offensive broadcast content. A message from the Broadcasting Commission.
Make it a new day, yeah.
Bring it.
Bring the love.
Love one another.
Your teammates, friends, family, and partners.
Bring the knowledge.
Get the facts about HIV
at iliveUp.com.
Know your status.
Get